everyone, I'm Tamron Hall. The News Nation is following continuing coverage of the George Zimmerman trial, where we just saw a dramatic moment, an exchange between the judge, George Zimmerman, and his attorneys when the judge asked Mr. Zimmerman if he plans to testify. Listen in.
Mr. Zimmerman, sir, I spoke with you this morning about your rights to testify if you want to, and the fact that you do not have to testify either. The jury cannot consider that in their deliberations of whether you testify or not. Did you have an opportunity to talk to your attorneys about whether or not you want to testify in this case? Do you need some more time to talk to your attorneys about that?
No, Your Honor.
Okay, and if you'll please just raise your right hand for one moment.
You promise to testimony about the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Okay, and Mr. Zimmerman, like I said before, you're aware that during this trial you have the absolute right to remain silent. You do not have to say anything, do anything, or prove anything. Is that correct?
Yes, Your Honor.
And you also have the right to testify if you want to. Do you understand that?
Yes, Your Honor.
And I've given you an opportunity to discuss with your attorneys whether or not you want to testify in this case, and you have indicated that you have had those discussions.
Yes, Your Honor.
And have you made a decision, sir, as to whether or not you want to testify in this case?
I object to that question.
Okay, overruled. Have you made a decision as to whether or not you want to testify in the case?
I object to that question. I think that's Mr.
Overruled. The court is entitled to inquire of Mr. Zimmerman's determination as to whether or not he wants to testify. Mr. Zimmerman, have you made a decision as to whether or not you want to testify in this case?
Not at this time, Your Honor.
Okay, and when is it that how long do you think you need before you make that decision?
May we have an opportunity to speak? The case isn't concluded yet.
I understand that, and I've asked Mr. Zimmerman if he needed more time to talk to his attorneys, and if he does, I will afford it to him. Mr. Zimmerman, how much more time do you think you're going to need to discuss this with your attorneys?
I assume it would depend on how long the recesses are, Your Honor. At the end of the day.
Okay, well, if your attorneys have finished with 2 witnesses before the end of the day, do you think that you would then know whether or not you want to testify?
On Mr. Zimmerman's behalf, that decision...
I am asking your client questions. Please, Mr. West.
I object to the court inquiring of Mr. Zimmerman as to his decision about whether or not to testify.
Your objection is overruled. Mr. Zimmerman, I will give you more time, sir, to discuss this with your attorneys. Thank you very much.
Unrelated matter.
Yes, you may.
Okay, we're going to talk about that moment, but also want to get you updated on what happened prior to. The defense, of course, is preparing to rest the case, and they called Dennis Root to the stand. He's a former law enforcement officer and also an experienced trainer on the use of deadly force. Root testified that Zimmerman had no fighting skills and that he believed Trayvon Martin was more physically fit.
Comparing what I know of to the best of my knowledge for each individual, Mr. Martin was a physically active and capable person. Mr. Zimmerman is an individual who is by no stretch of the imagination an athlete, and that his physical, I believe, it's my opinion, that the physical abilities he would find himself lacking when compared to Mr. Martin.
Under cross-examination, Root admitted that this is his first time testifying as an expert witness and that his consulting firm would benefit from the publicity from the trial. And prosecutor John Guy also asked him about the screams for help heard on the night of the shooting.
If a person sees a firearm, would it be unusual for them to yell for help?
If an average individual saw a gun and it was pointed at them, I would say absolutely not. Anybody looking down the barrel of a firearm, if you're able to vocalize something, would probably yell for help.
This morning, Judge Nelson issued 2 key rulings in the trial. She barred the defense from introducing as evidence this computer animation, which depicts George Zimmerman's version of events the night Trayvon Martin was shot and killed. She did say the defense could use the animation in closing arguments. And Judge Nelson also barred testimony about 17-year-old Trayvon Martin's text messages that purportedly discuss fighting. Zimmerman has pleaded not guilty to second-degree murder and says he fatally shot Trayvon Martin in self-defense. Trayvon Martin was unarmed. Let's bring in MSNBC legal analyst Lisa Bloom and criminal defense attorney John Burris. Let's start at the moment that we just witnessed, which was extraordinary, Lisa. I was watching from afar. You were here as well. I didn't know if George Zimmerman was about to be the next witness on stand. What happened there?
Yeah, and apparently he didn't know if he was going to be the next witness or not. Usually what happens is at the close of the defense case, after the last defense witness, a decision is made to testify or not. If the decision is not to testify, the attorney notifies the judge, and then the defendant gets questioned outside the presence of the jury, but on the record, to preserve the record so that later on they can't say, oh, my attorney tricked me, I didn't know I have the right, etc. So they just go through a series of questions. You understand you have the right to testify, yes. You waive it freely and voluntarily, yes. You had a chance to speak to your attorney, yes. That's what we all thought this was going to be. Instead, Zimmerman looked confused, as though he hasn't really decided yet. His attorney objected a couple times to the judge's own questions, which, of course, you can't really object to the judge's own questions. Not surprisingly, that was overruled.
Right.
I think what his attorney, Don West, was trying to do was to say, this isn't the right time yet, Your Honor, because the defense still has a couple of witnesses, but he wasn't able to get that out. And so we saw that extraordinary exchange in the courtroom.
What would it be the Judge Deborah Nelson's motivation here? Would she have information perhaps that George Zimmerman wanted to testify or wants to testify and his attorneys continue to advise otherwise? What would be the motivation at this moment, at this time, for her to press in that very specific and direct way to George Zimmerman?
Well, she referenced a conversation that had happened earlier, and I think she probably thought this was a pro forma moment. In other words, they were just going to go through that litany, get it taken care of, you know, move on to the next witness. I think she was as surprised as anyone at the answers that she was getting.
So, John, what's your take on what we witnessed there?
Well, I was really surprised at the judge pressing the point. From a defense point of view, you certainly don't want to have to make this decision about whether your client is going to testify, even if you know, because to some extent it's a gamesmanship effort that's going on here. You don't necessarily want the prosecution to know. So I thought that Don West was appropriate in letting the judge know that he didn't like this particular thing. I think the judge's issue here might be more of scheduling as well, because, I mean, you have these, she has these sequestered people here and that jurors, and that she may want to know, because if he does testify, it's going to extend the trial for another day. So I think in her own mind, that's what she's really trying to get at. I don't think she was really trying to interfere. At the same time, the defense lawyers really trying to protect their client. They don't want to make that decision. They don't want the prosecution to know what they're going to do yet. So I think that they were both right in what they were trying to do. It was very, very surprising, though, and I think the judge was a little more aggressive than she should have been.
We at least know that they're planning to call perhaps 2 other witnesses before arresting. But let me bring you in, Lisa, on this Dennis Root. He's on the stand right now. This guy is a former law enforcement officer and said to be an experienced trainer in the use of deadly force. But as he pointed out today in his own testimony, in a sense, he's advertised that he would be part of this trial and that he knows he would benefit from the publicity. He's never been used as an expert before. With that said, he's making an expert assessment or opinion on who was more physically fit in this fight. He did not meet Trayvon Martin, did not examine Trayvon Martin, did not spar or train with him, and he negates the physical difference in George Zimmerman in the trial right now and the George Zimmerman, his physical condition anyway, when this incident took place.
Yeah, he made a number of mistakes in his testimony. Really, all he knows, all that the jury knows about Trayvon Martin is his height and weight. We don't know how strong he was, what kind of background, if any, he had in fighting, and he made a number of assumptions about that. And you're right, George Zimmerman at the time was much slimmer and more in physical shape than he is now. He outweighed Trayvon Martin substantially. Trayvon Martin was a few inches taller, about 4 inches taller than George Zimmerman. I don't know what kind of conclusions you can draw about that.
Are you surprised that the prosecution did not attempt to object more or question? I mean, again, George Zimmerman was in MMA training or training with a trainer at least 3 hours or 2 hours a day, 3 times a week. And forgive me if I don't have the specifics, but we know multiple hours a day, multiple days a week. And this witness who did not examine either of these individuals, how does that process with a jury who's heard so much all day long and to hear this kind of what almost seemed irrelevant information?
You know, I think on direct examination, he came across well, but on cross-examination, he really had trouble answering some of these questions from John Guy, who was a very good cross-examiner. examiner. He also got tripped up on how light it was. We know from all the witnesses that it was a very, very dark night in February at about 7:15 to 7:30. He said he went there in the summer in June around that time, and it was fairly light out. You know, the jury has to know that that's a mistake.
Yeah.
And clearly he's got a small business. You know, he wants to be an expert witness.
Yeah.
God bless him, nothing wrong with that. But you go into a high-profile case, you advertise your services. You know, that's a little strike against you in the jury's eyes.
And John, let me bring you in. Dennis Root testified that obviously if someone was looking at the barrel of a gun, they would scream. There's no evidence, no DNA evidence, no fingerprints that Trayvon Martin was ever holding that gun, and that George Zimmerman was the person on the other side looking at the barrel of the gun there. And he admits and tries to connect, I guess, in a fumbling moment when he was under cross.
Well, you certainly can't connect the screams as everyone has tried to do with George Zimmerman suggesting that he was screaming and at the same time he has the gun. So that's one of those disconnects in the case. But I will tell you, from my point of view, you have a guy who would typically go to the defense, to the prosecution, and offer his services, having been involved in this case. It is quite surprising that he would go to the defense and volunteer his services in order to bring himself into this type of case. But I think that at the end of the day, all this discussion really, I don't think the prosecution had to do a lot on the question on some of these, because these are going to be really jury questions.
Yeah.
And whether the jury really sees these as significant, they're not going to want to believe that a guy has had MA experience, MA for 8 months, has no skill,
right,
as these people are trying to say. It defies logic and it doesn't make any sense. So I think they didn't really help themselves. I thought they overreached with this particular witness. They didn't really need to do it, and I think it helped the prosecution more than they thought that it would.
Well, and from the jury's perspective as well, John, and I don't want to go too far here, but I felt that perhaps they were even falling into stereotypes here, in that you have the young, agile African-American kid who would likely be more physical than George Zimmerman, who's not an old fella, but he was also in some type of physical training at a gym. He was not a couch potato sitting at home watching MMA. He was participating in it despite the skill level here.
Well, we know in this case there's a subtext of racist here no matter what, and jurors may or may not fall into that. I think it's better, though, to look at how illogical and disingenuous it appears to be that a guy who's going through all this kind of physical exercise, who was fit in terms of what he was doing.
And
he
the
may not
jury
have been
has
the greatest.
seen video of him. I mean, it's not as if there's not video or a picture that exists that shows the fitness of George Zimmerman.
He looks great.
Fit. Yeah.
You know? So I think that one of the problems you want to make sure is that the jurors don't get confused by how he was then versus how he is now. And that's going to be the prosecution's job, and they can see that for themselves. Right. That video is really helpful to go to that particular point, that he didn't look like a couch potato at the time.
Right. Let me bring in Craig Melvin. He is in Sanford. Craig, let's talk about the judge's decisions today, which included a decision on this animation we've talked so much about, when the jury might see it, as well as these text messages that were recovered from Trayvon Martin's cell phone.
Text messages out. Text messages and pictures completely out. The jury will not see those in any way, shape, form, or fashion. Now, the animation, on the other hand, and we keep calling it an animation, but apparently it's now it now more closely resembles several stills, and there are a few animations in those stills. Judge Nelson ruling today that the animation itself cannot be used as evidence, but can be used as a demonstration, meaning that the jury at some point can see it. They will not be allowed to take it into the jury room with them when they deliberate. Right now, we can tell you that there's, of course, another sidebar going on. Judge Nelson is considering an objection made by the state. The state is objecting. The state launched this objection when Dennis Root was asked, was there anything in the use of the firearm that was reckless, referring to George Zimmerman shooting and killing Trayvon Martin. Was there anything in the use of the firearm that was reckless? He said no. The state immediately objected because earlier this week, Judge Nelson decided to limit the scope. She limited the scope of Dennis Root's testimony, and among the things that he cannot say in court is that George Zimmerman acted reasonably and that he also did not violate any of the laws of the state of Florida. So that's what that sidebar was about.
And real quick also, Craig, George Zimmerman's friend, John Donnellan, the man who said that George Zimmerman was his best friend ever, I believe is how he described him. Apparently, he violated the witness sequestration rule. He was sitting in court almost 2 weeks before he took the stand. What's the latest there?
Yeah, you know what? We've actually got a picture of him in court before he testified. Judge Nelson at some point is supposed to consider what to do about his testimony, whether to strike the entire testimony, whether to strike a portion of the testimony, whether to sanction the attorneys. At this point, we have not heard whether a decision has been made, nor have we heard if a decision has been made what that decision is. That's something that actually could happen outside the purview of the cameras.
And we're showing the video of Mr. Donnellan. He referred to George Zimmerman really as a son, in a sense, a best friend and son, but that was him in court. I believe the date was June 25th, and that was 2 weeks before he took the stand in his emotional testimony regarding his relationship with George Zimmerman. Thanks, Craig. Thank you very much, Lisa and John, as well. We're going to go to a quick break and resume listening into testimony after a short break. We'll be right back.